Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. This is one of those landmark cases that shapes how lawyers think. Have you ever wondered if a price tag in a shop window is a binding contract, or if a newspaper ad means the seller has to sell to you? Today, we're breaking down the critical legal line between an invitation to may help with and a binding offer so you can protect your business and your rights. Alright, let's start with the real-world problem. Understanding the difference between an offer and an invitation to may help with is the difference between being legally bound to a deal and simply starting a conversation. An offer is a clear statement of terms upon which the offerer is prepared to be bound. It isn't a suggestion or a maybe, it's a yes waiting for an okay. If the other party says yes, the contract is formed instantly, which is why the wording you use in business emails is so critical. An invitation to may help with is essentially an invitation to make an offer. It's the preliminary stage where you're window shopping for terms. Most people misunderstand this and think every price tag is a binding offer, but legally, it's usually just an opening move in a negotiation. Courts don't look at what you were thinking. They look at what a reasonable person would think your words meant. This is where businesses often overpay for legal mistakes by using language that sounds too definitive. If your quotes look like a promise, a court may help with it as a binding offer. If you mistakenly make an offer instead of an invitation to may help with, you lose the power to say no to a customer. This can lead to stock shortages or selling at an incorrect price. Knowing the difference allows you to control the offering process and protect your inventory levels. Now let's look at how these principles play out in shops and advertisements. These cases set the rules for every retail transaction you engage in today. In Fisher v. Bell, a shopkeeper displayed a flick knife in his window. Even though selling it was lesser known, the court held that the display was just an invitation to may help with, not an offer for sale. This case establishes that items in a shop window are merely invitations for customers to make an offer at the counter. This case involved self-service shelves. The court decided that a contract is only formed at the cash register when the shopkeeper accepts the customer's money. This is vital because it means you can change your mind about an item and put it back on the shelf before you pay. Most advertisements are invitations to may help with, not offers. In this case, an ad for birds wasn't an offer because the seller might not have enough stock to satisfy everyone who sees the ad. This protects businesses from being sued if they run out of a sale item. This is the big exception. The company promised £100 to anyone who used their product and still got sick, even depositing money in the bank to show sincerity. Because the ad was so specific and promised a reward for a specific action, the court ruled it was a unilateral offer that anyone could accept by performing the task. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. Negotiating a price is a delicate dance. One wrong word can turn an inquiry into a binding commitment. In this case, a telegram asking for the lowest price was met with a price, but the court ruled this wasn't an offer to sell. It was merely a statement of price. Just because a professional tells you their rate doesn't mean they're offering to work for you at that exact moment. When a company asks for tenders or bids for a project, they're usually making an invitation to may help with. They're asking you to make them an offer. This gives the company the freedom to choose the best bid rather than being forced to take the first one that arrives. Sometimes, the way a tender is worded changes everything. If a seller promises to accept the highest bid, they have made a unilateral offer. If you're participating in a bidding process, read the fine print to see if the solicitor has committed to a specific outcome. In a standard auction, the auctioneer's call for bids is an invitation to may help with. Each bid is an offer, and the contract is only formed when the gavel falls. However, if an auction is without reserve, the auctioneer is making an offer to sell to the highest bidder, no matter how low the price. Now that we know the cases, how do you apply this to avoid expensive mistakes in your own life or business? When negotiating, using the phrase "subject to contract" is a safe first check. It signals that you're still in the invitation to may help with phase and don't intend to be bound until a formal document is signed. This prevents accidental email contracts that can be very costly to break. If you have made an actual offer, you can usually revoke it at any time before it's accepted. However, communication is key. You may want to ensure the other party knows the offer is off the table before they say yes, or you could find yourself in a binding agreement you no longer want. When receiving a quote, check if it has an expiration date or specific terms of acceptance. If a quote is too vague, it might not be an offer at all, leaving you with no legal recourse if the provider changes the price later. Always ask for a formal offer if you want to lock in a price. In business, parties often swap their own standard terms. The last shots rule usually applies. The last person to send their terms before the contract starts usually wins. This is a common area where companies overpay because they didn't realize they agreed to the other party's fine print. If you're dealing with high-value assets, intellectual property, or long-term service agreements, the line between an invitation and an offer gets thin. A qualified legal professional can review your templates to ensure you aren't accidentally making binding offers in your marketing materials. That's the practical version of how offers and invitations to may help with work. The big idea is to be intentional with your language, so you don't accidentally enter a contract you aren't ready for. Remember, a price tag is just the start of the conversation, not the end of it. If this helped you understand the nuances of contract law, subscribe to Law Conquer for more case summaries and legal education breakdowns that help you navigate the professional world with confidence. Subscribe for more case summaries that make law study easier. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.